So let's all rise again for the national anthem. The first topic will be on legal debt recovery. That is the most conventional part. I think all of you all in the banking circle as well as in the finance circle know about it also. But here, Mr. Cecil Perra, the president partner, will give you an emphasis on this. So it's my duty. He's a colleague of mine when I was at Merchant Bank of Sri Lanka for almost 15 years. So he has his own firm, legal firm, that is there, and he is the president partner. Let me give a brief on him. Mr. John Cecil Perra is an attorney at law of the Supreme Court of Sri Lanka since 1982. He has a diploma in modern banking conducted by the postgraduate Institute of Management, Srija Vadanapura University, part qualified in Chartered Institute of Management Accountants. He has key positions held. Presently, is the chairman of Avant Finance. Is the present chairman of Atara Capital. It's an investment bank in advisory company regulated by the Securities and Exchange Commission. The founder and president partner of Legal Link, what I said. He is also the chairman of Legal Link Secretariat Trust, where trusteeship is done. He is the deputy chairman of Sri Lanka Resort and Spa, a 5-star hotel in Dambulla. Former chairman commercial credit for almost 10 years, it's 9 years I think, 9 or 10 years. Former director of 99X Technology for 12 years, a Norwegian IT development company. Presently in Asia Business Outlook magazine, he's been recognized. In the November issue, named him as one of the important persons. Top 10 most promising legal consultants for corporates in Sri Lanka for the year 2024. Further, in employment history, is an independent arbitrator since March 22 to date, senior partner, Legal Link, attorney at law and notaries public, April 2002 onwards. The head of legal when he was at Merchant Bank, we were together. From January 92 to March 2002. He was also started his career in DN Raja in practice for a very long period of time. The specialty of him is, although he is a lawyer, but in profession, he is more a corporate finance person. He understands all corporate finance and banking activities in Sri Lanka. So with that introduction, let me welcome Mr. Cecil Perra.
Ladies and gentlemen, I'm sorry for the small delay. Let's look at the debt recovery, the legal aspects of debt recovery. And I suppose most of you are not having a legal background, may not attorneys at law, but may have some sort of a legal knowledge. So let me first go through the contents. We will talk about the liens and set-off, then general procedure under the Civil Procedure Code, then the recovery of loans by banks, what you call the Parat execution, then the Mortgage Act, then the debt recovery, then what permits you to repossess vehicles and movables, then the criminal procedure where it applies, then the pawnbroker's ordinance, liquidation of companies, trust receipts, and so on and so forth. Okay, let's begin with the first one. Let's look at some sort of some aspects on sale of goods. As per there's an act called the Sale of Goods Act. There's an act called Sale of Goods Act. The Sale of Goods Act regulates the sale of properties, movables and immovables. As per the Sale of Goods Act, as per the section given, sale may be partly or entirely in writing, or it can be in words. A contract can enforce unless it's in writing and signed, or buyer accepts and receives part of the goods sold, or partly paid or paid in full. Otherwise, you cannot enforce a contract although it is entered into. There is also an implied condition under the Sale of Goods Act that the sale has a right to sell, the seller has a right to sell, then the buyer has a right to enjoy possession. Once you buy, you should have the right to enjoy the possession of that. Then goods are free from encumbrances. There cannot be any encumbrances. So once you sell, those things have to be ensured to the buyer. Buyer has a right to expect that these things are there. Then the title of specifics and ascertained goods will pass where it is intended to pass. Then the stolen goods will revert back to the offender when the offender is convicted. That means you have to be very careful in this. If you buy a stolen good, you may not get the title to that. Once the offender is convicted by the courts, you will have to return back the sold good or the what you purchased from whoever. So you have to be careful when you are buying goods which are stolen. You will not get the money nor the asset ultimately. But that rule will not happen to where the goods are not stolen but taken by fraud, like the lien, pledge, and set-off, what is it all about. Lien is a right to retain an asset against an amount due. You will find that there are two aspects to that. For you to retain an asset, there should be amount due to you. Otherwise, you have no right to retain that asset. The course of business, the lien has to have where the asset has come to you in the course of the business. For instance, if somebody goes and deposits in a bank vault, gold, anything, and the bank thereafter he deposits the bank on some other facility, the bank cannot have access to the gold in the vault. Because then the set-off is the appropriation of assets against the dues. Banks have the right to set off borrowers and third-party assets if the borrower is a guarantor. In other words, bank should have a right against the guarantor. Bank cannot access the guarantor's assets unless a third-party asset unless the third party is a guarantor for a borrowing made by another party. No right without the court's assistance. All other instances, you have to go to courts and get court's assistance. It can be pledged without the consent of the owner, legal owner. Lender could sell the property without recourse to courts, if so initially agreed. there should be an agreement between the parties, and in that agreement, the right to sell should be given to the lender. Otherwise, lender on his own doesn't get the right. So we have to be careful when you are doing an agreement to have the right reserved for you when the borrower defaults, for you to have access to the assets and to sell it. This was common, this practice was common among finance companies mostly. I can remember when I was in a finance company, we gave some facilities based on vehicle tires, and the borrower defaulted. So the finance company went and took control of the tires and sold it and recovered their dues. So things like that can happen. Then when it comes to, when we are talking about the recovery procedures, generally the recovery is done through the Civil Procedure Code. Civil Procedure Code governs through the courts, you get the possession. Then there comes a writ of execution, where you go and seize the property. You are not taking the possession of that, you are only seizing it. And then you have to keep it somewhere, and thereafter it has to be auctioned by an auctioneer and then sold and recover your money. At the auctioneer will value the property or the asset, and then there will be an upset price. The minimum value will be the upset price. So then thereafter, for the balance, you may have to look for other assets of the borrower. Then also, in a writ, you have the writ execution pending appeal. What happens is, generally, when you win a case, the other party goes and appeals in order to the other party. When you appeal, pending appeal, execution. Then resistance on writ execution is a contempt of courts. Most lawyers also doesn't know about it. You have to be very careful when the court officers come and try to execute a writ. You should never resist. If you resist, the court auctioneer will go and report to courts, and the court will charge you for contempt of court. So you have to let the court process to happen smoothly. If you go and resist it, then you are in trouble. So you have to be very careful about it. A lot of people do not know, and they do not take it that seriously. Sometimes they go and resist. Especially sometimes the lawyers, there's an amendment brought in where you can access other assets also other than the mortgage asset. So you have the access to the mortgage assets, plus if there is not enough money, you can have the access to other assets, provided there's a particular declaration has to be taken at the time of mortgaging the asset. Then the process that you have to do is, you have to suppose resolution and publish in 14 days, and then sale and purchase. The bank has the right to purchase at a nominal price. Generally what happens is, banks purchase those days at 1 million rupees or even 100,000 rupees. That's the nominal price. But of course, by law, they cannot keep it in their books. They have to resell it. And if there is an excess, they have to return the excess. But only thing is, I think practically it doesn't happen, and most probably, even after reselling, you will not have excess, because your interest would have accumulated, and then as a result, there may not be excess, and also the asset would have depreciated by that time. Then the purchase is entitled to get possession through courts. Then what happens is, if you take a house, someone is residing in a house, then what happens? There's no point in having the house without the possession of that. If you can't enter into the house, what allows you to go through the court, take possession of the asset also, or the house, and enter into the mortgage. Of course, then you cannot, under this particular act, you cannot evict the tenant. Then you have to go seek the assistance of the Tenancy Act and all that. But what the bank then does is, they enter into a postponement, deed of postponement. So before entering into the mortgage, at the time of entering into the mortgage, they ask the mortgagee to enter into a deed of postponement, which says the tenancy will be postponed to the mortgage. So the mortgage takes priority, tenancy agreement takes secondary. So that is why you get out of this. The same thing for the debtors also. Then we come to the Mortgage Act. The mortgage assets only, under the Mortgage Act, the section 46 says you can recover from the Mortgage Act only, the mortgage property only, your dues. But of course, there are also, we can have, which you can go for other assets also. So you can, apart from the mortgage asset, if the mortgage value of the mortgage asset is not enough for you to recover your dues, then you can go against the other assets of the borrower. Under the Mortgage Act also, the sale and the purchase happens after the certification by the auctioneer. Then after if there's a balance due, after recovering your dues, then you have to return the balance. There are also the purchasers entitled to get possession through courts under the Mortgage Act. Except to this is like the other one, the tenancy and the debtor. Same provisions. You have the right to get the vacant possession of the house. Then also under the Mortgage Act, shares can be mortgaged, and it's only from a credit agency, approved credit agency. All banks and finance companies are coming under as an approved credit agency, and there should be an instrument of mortgage. Then there should be a certificate, original certificate. Then it should be a signed transfer form. This is how it's done. But special to that, on top of that, or in addition to that, sale of shares can happen through a margin trading account, provided it's a listed share. So this permits whoever the lender to sell the shares and recover its dues. Otherwise, we can go through the process of this instrument, then certificate and sign transfer form. But only the approved credit agencies, or in other words, banks and finance companies do that, others cannot. Then we come to the most important thing, the legislative, the Debt Recovery known as, in other words, Debt Recovery Special Provisions Act. There have been about 3 or 4 amendments to that. Whoever entitled to seek relief or the benefit out of this act are the banks, then the NABDAC, of course, now they are also now commercial banks, then the debtors. So this is a new provision brought in, or something new, which was not there earlier. Only thing is now the amount has to be, debt should exceed 150,000. It can't be less than 150,000. Then you cannot claim, you can claim interest more than the capital. You know, under this body, what the court will do is make the debt decree nisi, issue a decree nisi and make it absolute. Then if the permission to file answer, it can do either court might ask him to pay of property, or in other words, the transfer of property after the decree nisi is issued. In other words, immediately once you file the action, the decree nisi will be issued. So immediately once you file the action, any alienation of property or transfer of properties will be void. So it's not effective. So that's a very important and very strong provision in the Act. So this is what, to me, the most important provision in this is. So any transfer is not valid. Then also under the Debt Recovery Act, you are given the benefit of suing for a return check to installments in default and things like that, and giving notice to the other side. There's a procedure. So thereafter, it enables for you to pre-possess the vehicle. So wherever there's a vehicle is given on a lease or hire purchase, This enables you to repossess possession, and it is given by act. You are given the act. The act gives you your legal right to repossess it. And also, if you come to the Consumer Credit Act, it makes an unlawful disposition a criminal offense. So, in other words, if you know there's an unlawful disposition of the asset, you can go and complain to the courts, and the court will arrest the person and charge you. So, under the Leasing Act also, leasing lessor can seek court assistance to get possession of a missing vehicle. If there's a missing vehicle, or get a court order and then go and seize the vehicle, and then take it into the court custody, and thereafter you can litigate, and the vehicle will be in safe custody. So that's also novel procedure under the Leasing Act. Generally, the police entries have to be made before repossession. You cannot use force or break into the premises, and you need to have absolute registration. Only thing is, also you have to keep in mind, the Mortgage Act or any other act, there's no act allows you to seize a mortgage property. You can only seize a property or an asset given under the Leasing Act or the Consumer Credit Act, in other words, hire purchased or the leased assets. You cannot seize a mortgage assets. There are people who have seized the mortgage assets and got into trouble. Because no legislation gives you that power. The Mortgage Act doesn't give you the power to seize the asset without the court's assistance. So you have to go to courts if the vehicle is mortgaged. Sometimes when the vehicle is mortgaged and you have this absolute ownership with you, you may complain to the police and go and seize it. But it's very dangerous. Police can charge you for leased and seized. The trailer attached to the prime mover was not leased, but it was seized because it was attached to the prime mover. When you seize the prime mover, trailer also was seized. But they went to courts, and then the courts, you are charged for robbery of not the prime mover but the trailer. So you have to be careful. You have to be very careful that what you are seizing is only the leased asset or hire purchased asset, nothing else. And also I would like to say, when you are talking of the Hire Purchase Act, under the Leasing Act, you need to register with the central bank for you to do leasing. But in hire purchase, under the Hire Purchase Act, you don't have to register with anyone. Even an individual can enter into a hire purchase agreement, and there are finance companies. You can't call it finance companies. There are companies, sometimes big companies. They do hire purchase without registering with the central bank. They do business in millions and billions, but not registered with the central bank. So it's not covered by the central bank regulations, but still you can do the business. But of course you can't do leasing business. If you are doing leasing business, you have to register with the central bank. But hire purchase, you don't have to register with the central bank. That's also one of the problems. I think they are being monitored by the central bank, and they are subject to central bank regulations. But at the same time, their competitors are not subject to central bank regulations. They also do the same business, the hire purchase. So we have to keep in mind that is still permitted under the law. You don't have to have a registration with anyone. Only the company registration is good enough. Even as individuals, you can enter into hire purchase with another individual and a group of people. So that doesn't allow you to go for a criminal action. You have to be satisfied with a civil action. In other words, claim action or claim of damages. But there are instances where the criminal procedure courts allow you to file action under the criminal procedure code as if it's a criminal act in the magistrate court. Then the checks also, then it comes to checks. When it comes to a dishonor of check, you have a right to file action in the magistrate court. As I said, this comes under the penal code, section 398, illustration D. It's a fraud. Check dishonored, issuing a check and getting it dishonored is a fraud. So, but it cannot be a check given as a collateral or given as a security. It has to be a check given in settlement of consideration or in settlement of a consideration that check dishonor is a criminal offence. You can file action under the Debt Recovery Act in the magistrate court. But there are also same conditions are there. It cannot be given as collateral or security, but it has to be given as settlement of consideration. Licensed commercial bank, a specialized commercial bank, or a finance company. You cannot, ordinary people, ordinary company cannot use that. If there is an ordinary person or ordinary company, then you have to go under the penal code and use that, exercise that right. So that's the only difference between the two. Then comes the trustees ordinance. We will see that you might be, if you have some influence, you may be able to get a license to do pawnbrokers. I know a lot of people, individuals, who do pawnbroking. You don't have to register with anyone. You don't have to register with central bank. You don't have to register in any organization other than this. Divisional Secretariat will issue the license. So once you have the license, but if it is a pawn, then there's a procedure given in. So because the procedure is simple. Then it's another legislation is a lot of people are not aware of this liquidation under the Companies Act. It's also very strong. It has very strong provisions for you to recover. This is done under Section 271 of the Act. For that, there should be more than 50,000, or there should be a discrete after 1 week. Then publish that in the Gazette and newspapers. Then filing a list of those. When you publish a Gazette and newspapers, you give the publicity to that. So the people who sees the newspaper and the Gazette have to write to the person who published that and say that I also have a claim against this company and this is my claim. So the person who filed that application or who did the Gazette notification or the publication in papers will have to collect all those informations and report to the courts on the next day. So what the court will do, when you have arbitration clause in the agreement, you can't go to courts. Then you can't use the provisions under the Debt Recovery Act. So you have to be careful when you are putting arbitration clause into the agreement, because you are ousting the jurisdiction of the court. And also, the arbitrator has no jurisdiction or no powers to issue interim orders. Interim orders like enjoining orders or interim injunctions and all that. So what people do is when you put the arbitration clause, you keep the right. If you want to exercise interim order, get interim orders or enjoining orders, you have a right to go to courts, something like that. Some exception to that, to the rule, you put in the arbitration clause. So that enables you to go to the courts if you want to have some interim relief. If you do not have that particular clause in the arbitration agreement, then you will not be able to do that either. So always when you enter into arbitration agreement, ensure that that particular wording is also there in the arbitration clause. Then once the arbitration is entered, the award is given, it has to be executed through courts, especially it has to be done through the high courts. And also enforced, we can have foreign arbitration also enforced through courts, foreign arbitration judgment. Thereafter, a decree is entered and decree proceedings followed. And when you are having an agreement, there are two areas that we have to look at. One is the applicable law, other one is the jurisdiction. Especially if you are entering into arbitration, putting arbitration act or arbitration provisions into an agreement, enter it into a foreign company or foreigner, ensure that the jurisdiction is put as Sri Lanka. Otherwise, you may have to they will like to go to Singapore or in England or somewhere. So ensure that the jurisdiction is put as the Sri Lanka, so that arbitration has to be held in Sri Lanka. At the same time, the applicable law also important. If you put the English law, then English law will apply. So you'll have to put the Sri Lankan law will apply. So ensure that once you enter into arbitration, or rather include an arbitration clause in it. So there are unauthorized taxes. I mean, we are not looking at that. And also, since we are also talking about the debt restructuring, I just put in some tools that we use for debt restructuring. One is the infusing the capital, own capital, third-party capital, or public funding, IPOs and all that. Restructuring or rescheduling outstanding liabilities. Then new loans, it can be overdrafts, term loans, bridge finance, and working capital. Then can enter lease agreements, operating and finance leases, or hire purchases.
Thank you, Mr. Mehra. I think it was a wonderful coverage that you made. Almost all areas that are there. I think you would have got the conventional way of recovery on the debt recovery possibilities that are there. Now let me take over now. And before that, as a I think tradition, is good that to know a brief introduction will be given. Then I will come.
The next speaker is Mr. A.M.A. Carter. He is a fellow chartered management accountant of CGMA. He has a master's in business studies from the Columbia University. He has a master's in information technology and a postgraduate in economics and marketing. He has multiple overseas experience in corporate finance from Citibank Singapore to capital market training in Westpac Australia, restructuring management done by the United Nations UNIDO. In top of that, he has experience from Justica, where he has done multiple training programs around Japan for a large part of his career. Mr. Carter brings in 25 years of experience and has a proven track record in corporate advisory, capital markets, and fund management at Merchant Bank. And he possesses over 40 years of overall experience in financial management, management accounting, and treasury management. So without further ado, I would like to invite Mr. Carter to give the next speech.
Thank you for that introduction. Now we'll go into something different. Difference is what Mr. Pera told is exactly what most banks can do. And some of the clients deserve it. Let me start like that. Some deserve it because they intended come to basically ensure they get a better hand. So you can't keep the normal legal debt recovery aside. That is not possible. But there is a but, no? The but is all are not people who are basically defaulters. That is why the central bank, after the economic downturn, said each institution you should have a recovery and rehabilitation unit headed by at least a manager or an AG. Am I right? That is there. So that in all possibilities, they can be rescued like a human being. When you have a human being also, you go for the OPD treatment. You go for emergency treatment. You get admitted. Then the extent is that you have to go to intensive care unit. So when you go to intensive care unit, you don't die, no. Chances are there that you could not make them to die. You have to, someone other, the doctor has to see possibilities to recover them. So with that note, we start. So what is conventional restructuring? Conventional restructuring is what you all do, extension. Extend is the period, a composition, togetherness. Sometimes a debt to equity swap. I have seen because in my career I was not in the conventional. I was totally in the corporate finance in investment bank. How to rescue people. That was my specialty. 25 years at Bank of Sri Lanka, Merchant Bank, parent also, I used to trade. Now extension occurs when creditors agree to lengthen the debtors' firm repayment period. That's very common. We saw in the Corona time, the economic development extensions are given. Creditors often agreed to suspend temporarily both interest and principal payment. Restructuring normally is accompanied in bringing together the individual debt into one composition. එකට දාන ඔක්කොම. අපි ඒක එකට දාලා මාස 48යි නැත්නම් 60යි depending on the cash flow. දාලා we try to accommodate. Sustainability I don't know. They I don't do it. Then looking at debt to equity. Sometimes there are interest components that cannot be taken. The institution will agree to convert that component into equity. That's a bonus. Then if there are bonus shares, you can see it can be sold. So common example, someone who is unable to keep making payments on a say mortgage 250,000, the mortgage might reach an agreement with the lending institution to reduce the mortgage to 75%. So 107,500. In return, the lender might receive 40% of the house sale proceeds when it is sold by the mortgage. Another debt restructuring, these are common things that you all know, refers to the refinancing process, where the company having cash flow issues comes into arrangement with the lenders to renegotiate or flexible terms that are there to save themselves from bankruptcy. So that you can, so I will discuss all this in 4 cases. Case 1, case 2, case 3, case 4 to get the outcome coming. Why there is a need for creative debt restructure? It's a breakthrough thinking. Today I am bringing you some of the Harvard Business School thinking also. What is needed? Restructuring is when company makes significant changes to its financial or operational structure. That is very important. When lender gives money to the borrower, when restructuring takes place, it doesn't take place financially. That is wrong. It has to take place in their operations also. A combination, financial and operational. Sometimes financial alone, depends on the case. As we know, COVID-19 has been a huge hurdle to all the businesses. Then we saw the next phase, no? Or that the economic downturn. At that time, a preliminary survey was done by Asia Securities, an investment bank. They are also an investment bank. They say 30% obtained required funding. 40% businesses indicate uncertainty. 40 indicated uncertainty. They had problems about servicing their debt post moratorium. This moratorium thing came, no? During the COVID. Was it good? I don't think. Most of them are still having problems in the moratorium. Therefore, banks as lenders need to re-evaluate. That's what central bank told. Why not? You have a separate unit. Their clients' business outlook frequently in order to provide clear post-moratorium solutions and funding. Central bank also realized later to do that. They gave the moratorium circulars. Circular 1, Circular 2, the 4% working capital, they gave. Then only they came out with this. Why business financial restructuring? Pandemic induced, that I understood, economic uncertainty. But it is not only the issue challenging companies today. The economic downturn took place. Now, let me tell about the economic downturn. Once upon a time, we heard about this Great Depression that was happening in Great Britain. At that time, many businesses fell down very badly. So much so the Commonwealth countries also had effect under that. Now, in our case, did we undergo a depression or a recession? In our case, did we undergo a depression or a recession? We underwent not a recession. We didn't undergo with a recession. We underwent with a depression. That means we are not in the emergency unit. We are in the intensive care unit. We were in the intensive care unit. That was there. So coming out of a depression, the country as a whole is not an easy task. It will take a long time. I know politicians, I don't want to comment. There are good things they have done. They have done fairly acute things also. But some good are there, you can't say that. As a whole in the country, they did restructuring, but that restructuring that was done not for the sustainability. Now 27, 22, I'm just starting the country. We have to start paying. Can we do that? It's a difficult task. But for the time moment, we have gone without doing. Even for our sovereign bonds, we did. Our rate went up to 34% also. We are the highest, and finally we became defaulters. Ended up with bankruptcy. Very few companies they didn't address. Most companies not realizing they themselves, the balance sheet, their own balance sheet has a lot of money. Some companies have. So it is a duty of the lender to go into that. Because why I come to that? There is a relationship. Now we have a relationship, not a shareholder alone. As a debt stakeholder also there is a relationship. That is why in your banks you have relationship officers, you have relationship managers that are there. That is because relationship is there. So it is the duty of the lender also to see you are submitting the accounts quarterly, you are submitting the accounts, you are submitting the original accounts annually. You are submitting the budget. See the balance sheet critically. What is the balance sheet? It's an asset and liabilities position. You can critically see. The liabilities are there. But critically look at the assets. That is also important. I always say I am in a hospital also. As a director, I say, me sudu aliyo inno, sudu aliyo. Sudu aliyo ඇදලා ගන්න. කළු අලිය තමයි ඉන්න ඕනේ. සුදු අලියට වැඩක් නැහැ. That is because there are machinery, there are stocks that are there which they complacently keep it. Happy, my fixed, you have asset coverage, that is there, all that. What is the point? That has served no purpose. It has to help the turnover to increase. If asset, white elephant, what's the point? So that is the duty of the lender also to see. It's meant from receivables and payables. Samara receivables deno, ondata deno. Payables match karan the receivables. They don't have payables to match the receivables. So that means who is benefiting? The debtors are benefiting. The debtors are benefiting. So you have to maximize your payables also. That is the efficiency. So that is a common situation. So smooth negotiation with creditors at early stage is very important. I tell that. And restructuring in a proactive manner, not a reactive. දැන් අපි ඔක්කොම වෙලා තියෙන reactive එකට නේ කරන්නේ. corrective reactive වෙලා වැඩක් නෑ. Beforehand you must be able to do a restructure. I'm going to, that's why you have chartered accountant, CFA, CIMA, all those people are there, no? They must understand the basic problem is they study this. They study, but they don't apply. So as bankers or lenders, you have to tell them, ඔගොල්ලෝ යන ගමන හරියන්නේ නැහැ. මේක ඔගොල්ලන්ටත් හොඳ නැහැ, අපිටත් හොඳ නැහැ. මේ දෙකම ප්‍රශ්නයක් වෙයි. ඒක නිසා දැන්ම හිතා ගන්න මේ தත්ත්වය වෙනස් කරන්න ඕනේ. Your business model has to change. Your operational business model has to change. Think that way. And then you do it. In the hospital also, I am there, I used to tell. This business model is only for bread and butter. No point having it for bread and butter. You have to grow. And you have to look after your shareholders, not only the lenders. They are looking after the lenders. No point, no. And I asked him very recently that you are showing this profit, no? Take that as a numerator. And take your share capital reserves as a denominator. See the return. What is the ROE? So shareholders, nothing. There is some problem. So that is very, very important. So that sometimes they say that, I am looking for an investor. That is also part of the story. Looking for an investor. When the investor comes, he will settle all the creditors. Now, investor story is a different story, I tell you that. Investor is like a marriage. Those who are getting married, you have to think, my son also is going to get married. So, you have to get the right partner. Very, very important. If you get the wrong partner just because you have money, gone. You are in a soup. One company I am there, it was in very bad shape. I can't tell the name. A very bad shape. Then he said, I have to come out. After COVID, I am in this bad situation. Can't you find me an investor? Then I told him, you can get the investors. We are a quoted company. We are well established. That is there. But remember, you have to get a right investor. To get a wrong investor, you are out. Finally, he was a very religious person. With good luck, he got a right investor. In order to settle most of his debt. And I told him, now your conventional way of doing things have to change. You have to change that. You go to some other area. And from one area, he went totally horizontal, not vertical. Vertical means forward, backward. He horizontally went. I said, good. Go horizontal and still make your contribution. That is always a plus. For the hospital also, I said, you are doing treatment and lab and all those things. That won't make your contribution high. You have to change your business model. How you change? Today there are a lot of this beauty culture. A lot of people spend a lot of money on beauty culture. And beauty culture is associated with Ayurvedic. It is associated with Ayurvedic. And Ayurveda supersedes in that area. Take for example spa salon. You know spa salon? They do extremely well. Not only in Sri Lanka, but outside Sri Lanka also. And their earning power is very high. So business models can't be traditional. Thinking that my father did this, my grandfather did this, my great-grandfather did this. I am also doing it. You can't do that. So as lenders, you have to harp at it because you are having a long relationship. So what is the beauty of it? In restructuring, I am telling all this story before I come to the case. It has to be a holistic approach. That's what the Harvard Business School says. It's the need of the hour reassessing. Holistic approach means many businesses do not see business financial restructuring as a need of the hour or essential tool, mainly due to lack of awareness of the restructuring process. It's like a health situation also. If you are eating and having a galata and drinking, you can't expect your health to prevail in the same way. Even without drinking, if you eat also, you lie in the same boat. So you have to have regular checkups. You have to have regular exercises. That is how the rest is left to you, the soul to be taken. According to your own religion, souls will be taken. Sometimes in your restructuring also, you don't know unawareness that there are legal issues. That Trati said, a lot of legal issues are there. That also you have to be mindful. A lot of contingency liabilities that are there. So all these are very important. So before I go into these cases, I will tell you evolution. Once upon a time, there was a situation where you do a deal on a one-shot basis, one-shot deal. One-shot deal in marketing. I am talking of marketing. All lenders here have a relationship, no? That is there. So once upon a time, it was a one-shot deal. Payment එක විකුණන්නේ. ගන්න සර් ගන්න බයෙන් දෙපා කිසි දෙයක් බයෙන් දෙයක් නෑ. ගෙදර ගිහිල්ලා දාලා බලන්න වැඩ කරනවා. ගෙදර ගිහිල්ලා දාලා බැලුවොත් ඒ වෙලාවේ ඊට පස්සේ වැඩ කරන්නේ. ඊට පස්සේ මාර්ක් ගන්න පුළුවන්ද? බෑ. That is එදා වැඩ කරන්නේ. දැන් කොහොමද අපි ගන්නෙ කොහොමද? This happened to me for my grandson's birthday also. I bought a toy. I didn't know that in the invoice they said one sold, it will not be taken. So small defect, they will take it back. That's a one-shot deal. I will never go to that place. And I want to tell the Consumer Affairs Authority about that case. That was the one-shot deal. Then the evolution passed further. Moments of truth. Every place the customer interacts, you have to satisfy him. That's why banks are having relationships. No, they call them relationship, but in reality, the relationship is there only in good times. In bad times, no relationship. Good times also you must have relationship. Bad times also have to have relationship. Airline and all, you buy from the travel, then you get the ticket, then you coordinate with the airline, how he responds, go to the airport, how you are treated, you go after that to the aircraft, how you are received, how you are served, how you are basically looked after. All those are moments of truth. So any business have MOTs. So MOTs managing was also one of the basis that was there. Then after MOTs, this so-called relationship came. That's why all of us, we have relationship manager, customer relationship manager, customer orientation, all those came out there. Today, according to Harvard Business School, that has also gone further up, advanced. How it has advanced? Today, at the research stage, when you introduce a product or service, you need to bring the customer at the outset and check with the customer how it is. And then only you do it. Otherwise, you will become a failure. So, see the evolution of how the relationship has bypassed. So that's why when they put cars by Toyota, the research goes very high. Toyota in that instance, so very good example, those who have gone to Japan. I'm not saying other cars are not doing that, even Honda, others all do. As a leader, Toyota does it very well, and including other cars, German cars, European cars, all those, they do the research. In service also you have to do. And in service also, customer is today is actually, I tell, as bypass God, God. Customer is bypass God. You have to delight the customer. If you don't delight the customer, your business is underneath. That's why banks are very careful, but still banks do mistakes. They don't understand sometimes. Institutions do mistakes. Then what happens? Customer, what does he do? He has choice. He has choice. He will switch over. You know, light light. So that is the situation. Now let me explain some breakthrough thinking. It's like a husband and wife combination. If you ignore it, you don't know the repercussion.
If the husband is the head of the family, the wife is the neck of the family, which can turn the head anywhere.
That is the outcome.
If the husband
So some of the breakthrough thinking techniques that can be considered is employees. That's also important. Today you have to understand employees, they talk about loyal people, loyal. There is nothing loyal, 20 years, 30 years. I know අපේ 100ක කාලේ ඉඳලා ඉන්නවා. The way forward, before I start the case, way forward is pandemic and current downturn in the economy is causing concern to all businesses. That we have first to survive, then stabilize, and then grow. Forget what happened, can't help, bygones are bygones. What is needed is to be applied, learn from the past, that is very important. Borrowers as well as lenders, both. Mistakes in operations and finance. Operation is correlated to finance, no? So you must get a best person who understands that case by case, business by business, so that they can be put into trial. So with that, let me start with the case. Case is, dear Herb, I will tell you this case, I won't mention the name. But although I don't mention the name, you will know who this person is. If I give the facts, no? That is there. Now this is a herbal medicine company acquisition. They were there for a long time. They were a subsidiary of a construction company. The construction company were doing well. So much so, even hotels of Jeffrey Bawa was built by this construction company. Kandalam, name many, all were done by the construction. So the main person, of course, had to go on the call of the creator. Call of the creator, he passed on. Others could not do the way he did. Before the crisis, okay? He could do the way he did, and he was indebted to various financial institutions. The financial institutions took whatever assets that were there in mortgage. They took whatever assets that were there in mortgage, and they saw a subsidiary. The subsidiary doing very well. But because of the parent, the subsidiary could not do at that time when they fall. That's what I'm saying. That understand the business, understand how that particular business is done. And to that, if you support, there will be growth. So what happened? The institution said, "May subsidiary ka vikunala da." Meka vikunala api ye sali gamu. So when they did that, they want to sell a chemical company. A multinational chemical company said, "I will take over 100%." I will take over 100%. Then the person who was running this herbal company ran and came to us. He ran and came to us saying, බලන්න මම මේක පටන් ගන්න මම පටන් ගන්න. මගේ නමට තමයි මම ඔක්කොම patents තියෙන්නේ and I am not a loss maker, I am a profit. Then if I give to a multinational 100%, where am I? And I said, oh, ඒක ඇත්ත තමයි. බැංකුව එමනේ බලන්නේ. ඒගොල්ලෝගේ සල්ලි ටික ගන්නයි ඒගොල්ලෝ බලන්නේ. එහෙම කරන්න බෑනේ. ඒක කරොත් මගේ තත්ත්වය මොකක්ද? මගේ තත්ත්වය bad. So I said, don't worry. Now how much you can bring? You have been there for about 20 years now. You and your key management, how much they can put money? Then they said, මම ඉතල සම්බු කරලා දුන්නේ ආයතනයේට මට නෙමෙයි. මාගා මිලියන at that time 1990 2007 it was in 2007 මාගා මිලියන 25ක් විතර ගන්න පුළුවන් 25ක් මගේ ෆයිනෑන්ස් මෑන් ඔක්කොම ගත්තොත් 40ක් 50ක් ගන්න පුළුවන් එච්චරයි. නමුත් මෙතන 250ක් එනවා. 250 is coming. And the multinational is prepared to buy over. So I said, don't worry. The shares are there now. We will tell the multinational, you have 55%. Now we are breaking the shareholding structure. You have 55%. The balance 45%, we work out the management share ownership plan. We work out a management share ownership plan. We have that. You put 50, we go to the bank and say we will, for that balance, 45% shares, we pledge it. That is there, the difference. Difference that is there, we get a loan from a development bank. It was a development bank at that time, but they were converting to a commercial bank. So they said, looking at the past, we can't do it alone on that basis. Because we are giving on shares, no. Shares are not like mortgage or property, no. That is there. Am I right? They said, can you get a comfort letter? Yeah, we give a comfort letter, no problem. I'll get the multinational to give a comfort letter. They gave a comfort letter and the company was just taking off. It was on the growth stage, going stage by stage. And we did the deal. You won't believe, as soon as it was done, all the banks came with the umbrella. මම දෙන්න. ඔක්කොලා එනවා කුඩේ අරගෙන. වැටලා ඉන වෙලාවේ කුඩේ ගත්තා. ඒක හොඳද? ඊට පස්සේ අවුරුදු 4කින් මේක ගෙව්වා. මේ herbal company 750ට මේක දුන්නේ. දැන් ඔයගොල්ලෝ දන්නවා කවුද කියලා. 750කට මේක උපෙල් පාට ගියා. අද මේක ඔබතුමාලගේ කැස්සට හෙම්බ්‍රිසාවට ඔක්කොම පාවිච්චි කරන දෙයක්. ඒක තමයි පාවිච්චි කරන්නේ. මම මේ ප්‍රෝග්‍රෑම් එක කරනකොට Zoom එකේ අර ප්‍රොමෝටර් කිව්වා මට එන්න බෑ කාඩ් මම හරි වයසයි. මම චෙයාමන්. මම බලන් ඉන්න ඔයා මොකද්ද කියන්නේ කියලා. He came for the first program that I did here. And today it's a 10 billion company for a month. Exporting to all over the globe. Imports are done from India 95%. Number one company. Don't you think like that? If you had just sold it, that man would have gone. He would have been, his motivation level would have come down. Motivation level would have come down. So that is the creativeness. As bankers, as lenders, you will have to look and make them aware this is what has to be done in an economic downturn. Case one. Case two. When I was at the bank, this I did the first management buyout. I think Mr. Cecil Perra was very instrumental in that. in that particular buyout. Here, again I can't tell you the name, but you will understand that. There was a multinational who were doing a pharmaceutical business. A multinational doing a pharmaceutical business. They thought Sri Lanka was not very attractive. They want to sell. But that multinational is a US business. Still they are there. Even today, when we had corona vaccine, they did that. They want to sell from Sri Lanka and go. They want to sell from Sri Lanka and go. So at that time, they were so loyal, they said, those people who are there, key management, why don't you find a way to buy this? The key management people didn't have money. They came running asking, how can we do this? Then we said, how much they are asking? They were asking for a sum. They wanted to take and go, no. They were declaring dividend 60%. And that dividend was repatriated. They have recovered their money over a period of time. So what happens? They are giving a concessional value for the company, not based on the values that are there, but a concessional to these employees. Again, we ask the question, how much you can come out? Then they said maximum. One person at that time said 5 million, another person said 10 million. You can't expect a big amount, no? They are all employees, no, in the management. So all added together, there was a figure. Then the balance figure, that is there, we have to do, no? So as investment banker, we did a bridging loan. Bridging loan. We did a bridging loan and settled the multinational. The bridging loan came into the outside. When we did this particular deal, it was under the old Companies Act, not the number 7 or 2007, Companies Act number 7 or 2007. It was under the 1982 Act. It was under the 1982 Act. There you can plug in a loan into the balance sheet. But you have to go to the court. Without court's consent, you can't do. A creditor's consent also must come. So all that was done. This particular company in good, I would say there's some luck also. They were in an area, little suburbs of Colombo. So they took it to the court. They made the creditors agree and got this bridging loan being bought into the balance sheet. Leverage buyout. Now you can't do. At that time you can do. And today, and they paid us. And they paid the bank. They paid the interest. Of course, there were, oh no, when you do deals like that, there are time taking, no. There were always hiccups. Hiccups will come. And there are hiccups, you drink water and take medicine and get over the hiccup. That's how the hiccups are taken over, no. And they got over that. And they are today number 1 in pharmaceuticals, animal medicines, syrups, and including Ayurveda. And their turnover is topping closer to more than 2 to 3 billion a month. And is owned by the key management people. They are still owning, and it is running as a public limited company, not in the share market. Second case. Don't you think there is creativeness? Third case, this of course happened before Corona. Not after Corona. They were I work out the internal rate of return, IRR. Worked out the IRR to see what they said in the offer letter. At that time was some 18%, 22%, but reality has come more than 30%. Took that explained one by one. Some banks understood, some revolted. One state bank supported. And they said, we support case by case for all your LCs. The other state bank said, උන් වංචාකාරයෝ. උන්ව ඉතුරු කරන්න ඕනේ නැහැ. කොහොම හරි වහලා දාන්න ඕනේ. That is the thinking that they had. ඒකට මම එක දවසක් ෆන්ක්ෂන් එකට ගියා. ෆන්ක්ෂන් එකට ගියාම අර ස්ටේට් බැංක් එකේ ජෙනරල් මැනේජර් හිටියා. ඉතින් මම ගිහලා පිටිපස්සේ ගිහිල්ලා මම කිව්වා I am a retired person. Now I am looking this from Bank of Sri Lanka Merchant Bank. That was another state bank. So you have to understand that I am also this company is doing this, and why don't you look at it? The other state bank is very humane, and they are trying to revive them. Huh? You are looking after this company. Who's telling? The general manager. You are looking after this company. Yes. I will tell you one thing to you. You will lose your reputation. You will lose your reputation if you lend your name. I know your name, but you will lose your reputation if you lend. I said, don't misunderstand like that. If you want, your other state bank is also here. Their general manager is also here. You come, we will have a chat with each other and talk. No, I know you are telling all this, but I have no hopes with them. Huh? They are very bad. They have done all these things. That's so anyway, you consider, will you? Then the political change. Political change also makes difference, no? They bought new chairman, this general manager went, another person came, he understood. And things were end out. And all the waivers were given, penalty interest all taken. So it's a straightforward thing, and they are now back on roads. Working under me as a manager. He had a father. The father had a big rubber estate, doing sheet rubber. He was doing that. So when he was doing this, he allowed the father to do, and he was a SEMA member also. He was working in the bank. And for your information, he was working in Ceylon Bank also. After that, he came and joined as a manager in my bank. Then he said, කාට මම යනවා මේ බැංක් මට වැඩ කරන්න කැමති නෑ මම ඕස්ට්‍රේලියා යනවා මට ඕස්ට්‍රේලියාවට යන්න ඕනේ මගේ තාත්තගේ බිස්නස් එකට මම මැනේජර් කෙනෙක් දානවා. And he went to Australia and he was in Melbourne. And once he did that, he was very innovative as father is doing now. And minding you, this company is a 50-year-old company, and the bank recognized him as the best client and gave them award also. Good times. It was in good times. Then, before Corona, he got an idea of getting what is known as scooter tires, scooter tires and auto wheel tires, which are discarded, rebuild that tire, He bought that machine from the state bank. I can't tell the name. And he bought it, and the rate was some 23% before Corona. And he bought it. Then the Corona came. No sooner Corona came, he started operation. You understand? He got badly affected. Then what should the banker do? The banker should have give them the respective circular rates and given them, because safeguard no. They didn't give. He was writing, he was chasing out. Last October, Parate was on. Now only Parate is off, no? On, off. Now off. That is the situation. So Parate was on, they advertised CGM recovery. I asked, I'm Carter. I was a former DG in Bank of Ceylon Merchant Bank to help me. Anyway, you bring the money and come will you, 10 million. And I thought it won't work. I straight away contacted the general manager. Why, I have a right now? I said, "Mata letter of authority ekak thoni." I spoke to the general manager in December. He said, "Carter, mata nang hari amaruයි, ඔයා කියන එක ඔක්කොම මට තේරෙනවා. මම කියන්නම්. මෙයාගේ නම කියලා කිව්වා මම කියන්නම් බය වෙන්න එපා." So previous general manager එයාටත් මම කතා. Second time I said, "No, persevering is very important here. One shot bad. Persevering is very important." Second time to the same DJ, sat near him. This time he was, "Mr. Carter, nice to see you. Very, very nice." He's speaking to me very well, very well. Then I said, "This is my former colleague. He is in this situation. He is prepared to pay 10 million. And you have to give, you are not given any of these concessions under the corona time. You had to give between 50 to 60% interest waiver." I told him it's a single digit interest rate and they have fallen down. So therefore, you give him at least 11 to 12%. And 5 years he can't pay, he'll pay in 10 years. He'll pay in 10 years. And normal is over. So this is what he needed. He was not a defaulter. He was not. So let me end. I think the end should be there. No? I should end in a good heart. So that you will also remember that the moon that you see from your own home is not the moon that you see from a mountain. And we have a very good singer, Amar Sirmir. Various verses. See how the rain during rainy times. That is when you go in the rain, the umbrella, don't forget him. Look at him and revive him. It's a very good, meaningful song. I stop here. Actually, it's a person who has come with a background of working in financial institutions. He is now in this organization as a general manager. And he has come at a most crucial time when Sri Lanka needs this type of thing. Otherwise, most of us, we always make the customer frightened. ඔයාව ක්‍රිප් එක දාලා තින්නේ. දැන් ඔයාට කොහෙවත් යන්න බෑ. ක්‍රිප් එක දාන්න ඉස්සර ටිකක් බලාගෙනයි. දැන් ක්‍රිප් එක නෙමෙයි, ඒක නෙමෙයි දැන් කියන්නේ. දැන් කියයි තව එකක්. ඒක තමයි the new developments of CRIP, application of development. So I will introduce the speaker, Mr. Pushpika Jayasundara, counts over 25 years experience in the field of banking and finance, out of which 12 years of working in two leading commercial banks in Sri Lanka. He had worked in the capacities in managerial, senior managerial, corporate management levels in the banking sector. Subsequently, he left the banking industry and gave leadership to two quoted non-bank financial institutions as director, CEO for over 13 years. He has hands-on experience in this. He has progressive experience in strategic planning, risk, credit management, business development and marketing, finance and treasury management, recoveries and debt restructuring, business process engineering, re-engineering and digitalization. He holds a master's in business administration, specialized in finance from the Sikkim Manipal University, and is a CIMA ICM person. He is presently reading for a PhD in economics at the University of Colombo. With this, basic words, let me welcome Mr. Pushpika Jayasundara, who is the head of TRIP. He is the general manager. Welcome.
Presentation, firstly having an understanding of the audience. So can I just ask, or if you raise your hands and then basically show that how many bankers are there in the audience? Then how many are there from NBFI sector? Okay. Then anyone who is basically owners of any business or SMEs? Okay. So we have bankers and NBFI, employees from NBFI. So if I may ask anyone from credit or risk? Okay. So rest is, I guess, from recoveries and basically just before you make your decisions on periodic basis, either for credit reviewing or when it comes to recovery. So these are questions that I'm asking. Say there are either 30 days, 60 days or 90 days. How many of you all go back and then see where the customer stands as a date in his credit profile? I would say credit standing. Any of you all? Just to have an understanding. Any of you all? Just before you make your recovery decision, say when the customer goes, I think most of the banks, when it hits 30 months, they basically get activated. Most of the NBFIs, when it hits 60 months, if you take Bangladesh today, if you take Philippines, Bangkok, the peers of ours, and if you take the developed countries like America, UK, Singapore, they do not make any decisions, any of the decisions that I told, if you don't have the data in hand. If you don't have the data, if you don't have the information, they will not take any decision. So this is the power, or this is the value of having information. So these are the three questions that I'm basically keeping you posted until my presentation is over. I'm not going to take much of a time because it's a long journey. I think we had two presenters presenting. So I will basically touch upon, talk about the credit bureau. I'm not going to talk much about it. These are the first credit bureau in the South Asia region, where Sri Lanka was fortunate enough to be the first again to establish a credit bureau. Why was it established? In 1980, there was a financial crisis. The financial crisis was due to the banking and finance disbursements and to follow up. So as a result, there was a huge crisis that the entire country or the financial sector faced in 1980s. At that time, the president was President R. Premadasa, who appointed a committee. The committee basically carried out extensive research in the developed countries. The research took almost an year, where the top officials of the central bank was involved, and as a result, this particular legislation, the number 18 under Act number 18 of 1990, through that the Credit Bureau was formulated. The Credit Bureau's main task is to see that the Bureau collects all credit information, all credit related data, and use it for the betterment of the financial sector, that is the banks and the NBFI sector. So we had 82 companies registered. With the consolidation, we have now somewhere around 70 financial institutions working with the bureau. So what we do is we collect the information, we send it through in scientific manner, where you make decisions taking credit information into into your formula of making decisions. So this is where credit information comes into play. So I can tell you, I'll give you the statistics for you to have an understanding. The Bureau collects around 90 to 100 million credit data for the year. This is approximately around 8 to 9 million a month. So we have increased this to 10 million during the last 3 months because we have already commenced collecting gold loans, margin trading and factoring data. So we have increased the collection data to almost 12 million today. Bureau issues on average 15 to 18 million credit reports for a year. 18 million, right? These about approximately 1 to 1.3 million credit reports per month. Facility wise, we grant somewhere around approximately 600,000 facilities for a year. CRIP issues self-inquiry reports. How many of you all know that there is self-inquiry reports to be obtained? Anyone know the brand name of it? Anyone? It's branded as My Report, right? So any public person or entity can obtain their credit report within 24 hours on various forms, on various tools to the banks and finance sector. So this is the importance of a credit bureau. So I'm talking not on technical terms, but on very practical understanding terms where anybody can have a understanding on the matter. So I'm not going to go into the history of it, where it says it's the first credit bureau in the South Asia. And basically it's all there. CRIP is an independent statutory body. We have been empowered by legislation, and it is mandatory that all banks and NBFIs share their credit data, and it is an offense under the Act if it is not shared accurately and in the form that we have prescribed. In addition to this, a presence of an advanced credit information management system is a very important task to provide these slides. Then credit information sharing lowers the unethical practices and adverse selection. Unethical practices, what are the unethical practices that usually, if the credit information was not shared, if you are unable to see the credit profiles of customers, the unethical practices that may come into play are...
Presentation that was done, as you see, the paradigm shift. I will use the one word, paradigm shift of the CRIP and how they are in the way forward. You saw traditional and non-traditional information, how they are going for the future. So I won't take much time. Now there is a moderator who will come into it of the fireside chat. In the meantime, there is an evaluation form. You are open to mark it. Please give that when you are going. So the fireside chat will last question.
Thank you, everybody. I'm sure all of you all have a bunch of questions, so we can get towards the Q&A immediately. I'd like to just check. I think we have one mic with us, right? Okay. With your question. For the moment, does anybody have any questions so that we can go into the Q&A session with the speakers? Please raise your hand and just proceed with the question. It's a very intimate crowd and it's a very small discussion. Yeah, a gentleman on the right side.
Giving individual rating and score. Likewise, whether the CRIP is going towards to giving the rating for industries as well. Because it's give us a clear picture whether we are lending to the correct industry. Because sometimes the customers may be rating will be A, the industry is collapsing. We don't know. If we can develop something kind of that, I think it will help for the finance industry. That's my question.
Plans, and we are working with Lanka Rating, Dr. Kenneth Kisilva, on giving and corporate rating for all corporates. So in this rating, what we are looking at is, we have to combine the CRIP data, that is traditional and non-traditional data, along with income data. Now, if you take a rating company, the rating company always rates a corporate. If you look at SEC, we have different boards. We have the main board, we have the Dirisavi board, we have the empowerment board. So different companies have been named under SEC, and in time to come, next year, it is mandated that all registered finance companies, all registered corporates have to submit their audited reports within 1 year. So that means basically all those, almost 90% of registered corporates, either it's private limited companies, sole proprietorship or partnership, next year need to register themselves and work on audited financials. Because Inland Revenue, it's through certain amendments, make it mandatory. So under these circumstances, we are basically going to capture all income data along with industry statistics, where do they stand, how much, what is their performance in relation to industry standards, and all those matters. This is like actually a rating, where we'll combine the Lanka rating data with CRIP data, and we will provide a corporate rating for these clients. So the banks and finance companies would be, it will help assist them to gauge an absolute correct figure on corporates when they are lending.
Restructuring, will other companies fail into the same or the previous situation, and what do you think you can put in place in order for businesses to not fall back into that situation? In your experience, what has been your thoughts?
Yes, it's a good question. Once you put a person to a creative debt restructure, he has to think that he has to sustain them. He can't just get away. Like when you go to the intensive care and you come back, you won't straight away go home. You will be kept in the room, and from the room you will go home, and from home also you can't basically do what you want the way you did earlier. So you need to do what is known as the banker or the lender along with him has to do monitoring and follow. That is what is needed to see, and it is the duty of the lender also to see that he is in the right track, whether he has come back. I don't know what.
Yes. Thank you. I think my next question is to Mr. Pereira. Mr. Pereira, you mentioned about various REITs.
Stopping a rate, yes, we have to be proactive that before the other party goes, we have to go there and then prevent the other party coming there. But at the same time, REIT is there to stop an immediate damage. That's why, there are 3 types of REITs. This one is the enjoining order, which is given just for the asking, it's a very temporary. Every 14 days it has to be renewed. At the same time, other party can come and show that it has been taken by presenting wrong data, information to the courts or misleading the courts. Then the courts will immediately take the enjoining order out. So likewise, it's very sensitively handled by courts. At the same time, thereafter you go to the other stage, interim order, interim writs, interim injunctions. Interim injunction is also until the permanent injunction is given. At that time, courts goes into details. Court will at that point hear both parties. When in the earlier instance, court will issue an enjoining order without hearing other party. Now both parties are heard, and then enjoyment or the interim injunction is issued, pending the permanent injunction. Permanent injunction means it's a permanent judgment. Or the body is permanent injunction, it is a judgment, final judgment.
If we have any more questions from the audience, we will be glad to take. Yeah, I think the next question I would like to ask is to Mr. Pushpika, which is, I think you mentioned the inclusive of alternative data or non-traditional data, and with this comes a new array of business or entire pool of credit lines that effectively comes into the market. Where do you see the initial opportunity for the likes of the NBFIs and the banks? So I think for their benefit, something, any thoughts?
Absolutely. I think all of the banks and the finance companies today the focus is SME sector. If you really see their growth plan is basically designed to facilitate SMEs and then see that there is a growth in this particular sector. So this onboarding non-traditional data would definitely help this sector, because there is the majority of people in this sector do not have proper credit profile. They have not obtained credit facilities in the formal structure. So onboarding non-traditional data and providing a profile for them will definitely assist to grant new credit facilities and get them onboarded to the formal structure. So this will definitely open new doors for banks and finance companies. As I said, move from red ocean to a blue ocean.
Servicing a lot of small time, borrowers. One of the big issues is, they change their address. They are no longer their address. They do not have permanent address. They go from rent. But at what point do you capture? Is it that when they take another facility? Is it? Or before that, there's no way of capturing?
Yeah, a very good question, Mr. Beda. How we do this is we maintain different databases. We have credit information on one pillar. We are basically capturing all non-traditional data on the other pillar. Then on the other side, we will be, now when you say non-traditional data, electricity, water, insurance, all data will be captured. So the customers' profiles are being captured. So what we do is we use a DSS, a decision support system, where we cross-examine the most relevant newly uploaded address. So if I take myself, if I have 3 addresses given on different occasions, the AI, the technology that we use will directly cross-check and find out the most recent updated address. And that will be used for the eKYC. We are basically launching an electronic KYC for the banking sector. So that will be used as the most updated demographics, so addresses and the telephone numbers of the client. So that is available with Crative. So anyone who wants to verify on these matters would be able to run through Crative on these products.
Now the consent of a client, we cannot obtain a credit report because of sake of canvassing a business. That is still, we cannot do it, no?
If you look at the banks and the financial sector, through the Act, the banks and financial sector is provided the legal coverage to get a credit report. So only thing, there is a certain formality. I think all officers have basically signed the declaration, and various other legal formats have covered. So they, for particular purposes, you would be able to, the bank or the finance company officers can get report. But individuals or who are non-members cannot do that. Only the members would be able to do that.
Looking at a client, can we take a report beforehand and see whether
Yes. So you say you today you have planned to go and visit a client called X. So before going, you would be able to recall, because that client should be in your database. So you can't get a client who is not in your database. So that client at the time of coming into your database has given the consent for you all. So anyone who's not in the database, you would not be able to take it.
That is the reason.
Yeah,
If
correct.
it's not in the base, you cannot.
Absolutely, yes.
Tactics in recovery. So what do you mean by that? I don't think you touched on it.
Yeah, I didn't want to touch on it because there are so many unauthorized tactics to induce the borrowers to come and pay. I mean, you discredit them in public. A lot of people, that's what they do. So that, they can't, their children or the wife or the spouse will, or the husband, we can't go through this harassment, public harassment. So, I mean, they come and shout and, sometimes they send you the postcards, say that you are in default and all that. So the postman sees that and, those trust. And sometimes they just come and visit the neighbors and ask, very well knowing that where you are, they come and ask the address and the person, saying that he has defaulted and, and then the neighbors comes to know about it. Then the following day neighbors comes and tells your spouse, where somebody came in search of you because there is a default, So these are the tactics, unauthorized tactics they are not really legal but not illegal either.
Thank you for sharing. I think that comes to the conclusion. I think I would like to invite Mr. Carter and final closing statements.
I think we had a very good interactive session. Anything else you want to ask? I'm very happy to impart on 3 areas. I'm sure all of you have got it. And anything else, you can have always a follow-up on it with Mr. Puspika on any matters related to legal recovery, Mr. Cecil Berra. And you want anything on creative industry, you can always contact. My numbers are all there. And I thank you all the institutions individually, and also the institution, and also those who are in the Zoom who have participated. A big thank you, and to our resource person, the Puspika Jasundar, who has spent a lot of time. He has basically done not wonders here. And as I said, it's a paradigm shift on the bit. I thank him, the Cecil Berra, a person who's in a legal, specialized in corporate finance activities, well-versed, who is there, who can explain anything. And he has been today being rated as one of the top lawyers by a most prestigious organization. So with all that, I think I wish you a very happy Christmas greetings and also the forthcoming New Year 2025. And thank you then, have a nice evening, nice evening to you and your families. Thank you then.